Okay, now we can move on to session number 3, which is the second session on the World Bank. Are there more people coming in? Okay. Yeah, so this is the second session on the World Bank, and this session focuses more on... Okay. This is focusing on the non-financing instruments and borrower approaches, and you hear this telephone tone now because our discussant, Vikram Raghavan from the World Bank, will be in the room sort of only virtually, so he can listen to us, but we will only sort of see him later on once the presentations are completed, and then he will give his comment. Just to check this, Vikram, can you hear us?
Yeah, I can. Can you hear me?
Okay, excellent. Yeah, we can hear you. Okay, so let's just start with Michael Riegner's presentation on the innovation at the Knowledge Bank, the role of law. Here you go.
Thank you very much.
Can you just tell me who's in the room, please?
Sorry?
I know. Can you please tell me who's in the room besides the two presenters? Is it a big crowd?
Quite a few people. Actually, all the people who you can see on the program, all the presenters. And then there are, let's say, about 15 to 20 other participants who are students, who are faculty members, or just the interested public, you might say.
Okay. Thank you.
Okay.
Okay, hi to everyone, hi to Vikram and Washington, and thank you very much for the opportunity to present to you a little bit of my thinking that's part of my PhD. It's particularly exciting because this is going to be my alma mater from summer, so I'll be here for the LLM and hope to continue the work on this with people here. Now, my title is Innovation at the Knowledge Bank, the Role of Law. And innovation obviously thrives on knowledge. And the global knowledge society has also brought about major innovations in development. This is more than evident in one of the leading institutions in the field, the World Bank. In 1996, President Wolfensohn declared his institution a knowledge bank, and in 1999, the World Development Report proposed to look at the problems of development in a new way from the perspective of knowledge, unquote. The report asserted that knowledge, not finance, is the key to growth and human well-being in the third world, and laid out a new institutional rationale for the World Bank, the provision of knowledge. Since then, the bank has embarked on a series of institutional reforms to implement this knowledge paradigm and to become what Martin Eifert has called a knowledge and information hub. My paper today is concerned with the somewhat neglected legal aspects of those reforms and inquires into two research questions, essentially. Firstly, how can legal governance of knowledge at the World Bank contribute to innovation in developing countries? And secondly, what legal innovations in World Bank law are thus required for governance of knowledge that enables innovation? Hence, I'm concerned with two types of innovation. Innovation through law and innovation in law. The main argument that I want to present in the following roughly 15 minutes is that, firstly, the shift from a finance paradigm to a knowledge paradigm is a major cause for innovation in the law and governance of the World Bank. Legal innovations are thus not only about new ways of delivering finance, but they're also about new ways of governing knowledge. Secondly, I argue that this legal governance of knowledge can and should contribute to innovation in developing countries, but it also needs to provide a more coherent, effective, and legitimate framework which systematically addresses both the risks and the chances of knowledge in development. To this end, I propose to reconstruct development cooperation law as a legal order of knowledge, or in other words, the law of development finance also needs to become a law of development knowledge. I unfold this idea in essentially 3 further steps, which you can see here. First, I present 2 opposing views of knowledge and development that influence the legal debate. then briefly elaborate on the concept of development knowledge law, as I term it, and then proceed in the main part to analyze bank knowledge activities with regard to institutional mandate, instruments, participation, as well as review and transparency. Now, what are the two opposing views of knowledge and of knowledge governance in development that law needs to somehow take into account? The first affirmative view is held by many practitioners in the bank and emphasizes the positive role of knowledge governance in development. It argues that knowledge for development needs to be provided by international public institutions because it's a global public good that markets and states lack the incentives or the capacity to provide. So the bank's most recent knowledge strategy document emphasizes that, quote, more than ever, development knowledge helps to define the bank's comparative advantage, end quote. And it lays down three knowledge roles for the bank: as a knowledge producer, as a knowledge customizer, and as a knowledge connector. In fulfilling these roles, the bank spends more than ever on knowledge activities, often funded from trust funds and not from net income. And it's strengthening mechanisms for governance of knowledge within and outside the institution. This positive vision is countered by three major critiques, which present a more critical view of governance of knowledge. The first criticism asserts that the bank does not know enough and doubts the ability of large hierarchical bureaucracies to produce innovative knowledge, to capture sufficient local information, as Hayek termed it, and to transfer global knowledge at all in the same way that capital can be transferred. A second line of criticism argues that, to the contrary, the World Bank knows too much and governs knowledge too much. For these critics, many from the post-development or post-colonial studies schools, knowledge is power, and centralized control over knowledge has the potential to entrench existing inequalities and hierarchies that already exist in the global knowledge society. A third and final critique argues that the relationship between knowledge and politics in global governance of knowledge is deficient. Either there's too much politics in seemingly scientific and objective knowledge products, or there's not enough politics in the sense that bureaucratic expertise depoliticizes development and limits political self-determination, or collective autonomy, as Philip calls it. Taken together, these criticisms also resonate with recent, more mainstream international law scholarship, such as the International Public Authority approach from Heidelberg or the recent GAL literature on indicators, for instance, the World Bank's Doing Business indicators. Now, my own approach builds on these literatures and proposes to reconstruct the existing rules of development cooperation law, treaties, secondary law, operational policies, etc., not only as a law of financial transfers, but also as a legal order that governs the production and the diffusion of knowledge and innovation. Let me briefly summarize three key features of such a law of development knowledge. A first feature is that the applicable law of development institutions already has two knowledge dimensions. Firstly, legal rules on lending also structure, often implicitly, the knowledge base for allocation decisions. And beyond lending, there is a considerable body of legal rules that apply specifically to freestanding, non-lending related knowledge activities. A second feature of these rules is that they often apply a different modus of governance. While lending can be subjected to more or less direct regulation, knowledge is often governed more indirectly through incentives or the creation of enabling organizational environments. Thirdly, the law of development knowledge performs two different functions, which react to both the affirmative and the critical use of knowledge in development. A first function is to enable and stimulate knowledge production and innovation, and thus to harness the chances of knowledge governance. Secondly, it also addresses the risks of knowledge governance and thus performs a limiting and legitimating function, provides mechanisms for participation and contestation, and enables what I will call epistemic ownership by the ultimate beneficiaries of development. Now, how do these ideas apply to the law of the knowledge bank? And this is the fourth part that I will now scroll down to. You can see this. Now, World Bank law has seen several innovations that already make it, in many ways, a law of knowledge. Some of these innovations concern explicit legal reforms, others more evolutionary developments, and in that sense, innovations, as Martin Eifert has used the term. They apply to different categories of legal rules, 4 of which I will discuss here: mandate, instruments, participation, as well as review and transparency. In the paper I discuss more, but I will limit myself here to those 4. Now, for lawyers, the question what role the World Bank should play in global governance of knowledge translates first and foremost into the question what legal mandate and legal powers the bank has with respect to knowledge activities. Here it's interesting to observe that the evolution towards a knowledge bank has not come with a formal amendment of the lending-focused Articles of Agreement. Instead, the bank has in practice made more use of the few explicit knowledge powers it has, such as the publication of reports and technical assistance, and has otherwise relied on implied powers, the doctrine of implied powers, fleshed out by secondary law, for those knowledge activities that are not explicitly covered in its founding documents. Hence, legal innovation here takes the form of institutional empowerment that enables, and to a certain extent that these powers have been transferred by member states, also legitimates the provision of knowledge. There are, however, also limits to this empowerment, which I discuss in more detail in the paper. Here I just want to highlight that in-house knowledge activities may at some point become dysfunctional. And in the paper I discuss instances where that might be the case and argue that in these instances the bank's mandate should probably be interpreted to limit the bank's role to stimulating external knowledge innovations by more suitable actors that are better placed or more adequately structured. A second type of rules where the bank has been particularly innovative concerns the instruments it uses to diffuse knowledge and stimulate innovation. For one, the bank uses financing instruments in new ways. It extends more grants to stimulate external research and South-South knowledge sharing. It increasingly employs lending as a vehicle for knowledge and for capacity building, as is the case in programming for results financing. And it has intensified the regime or improved the regime for impact evaluation, which has the potential to transform lending into an exercise of experimental learning and thus incremental innovation. A second and maybe even more significant innovation is that beyond lending, the bank has defined and codified formal knowledge products whose aim is to specifically to produce or to diffuse knowledge in developing countries. Some of these products have existed before, such as technical assistance, but it was only in 2003 that the bank defined so-called core knowledge products, of which we have 9 by today. These include, for example, technical assistance and economic and sector work, or a category of knowledge as a global public good, such as research on development, reports, and data. For instance, the World Development Report and the World Development Indicators. These knowledge products are now tracked in the bank's management information system and are subject to common rules on quality assurance and impact assessments to measure in how far they contribute to knowledge production and possibly innovation in developing countries. Now, this may sound on the one hand like more bureaucracy, but the significance of this formalization for the bank's more functional perspective is that it makes knowledge, amorphous as it is, somewhat more governable or manageable, and namely enables the creation of incentives, for instance, by rewarding staff for high-impact research papers. Now, the bank staff seem to get more money for citations, which is not something that we get. From the perspective of doctrinal research, however, there is a second purpose to formalization and codifying forms of action. Formalization also serves to identify legally relevant exercises of international public authority that impact on individual or collective autonomy and thus should be possibly subject to particular limiting and legitimating legal frameworks. If applied to the World Bank knowledge instruments, then namely unilateral rankings like the Doing Business Index or indicators qualify as such an exercise of public authority and thus potentially need to be subjected to legal requirements as discussed, for instance, in the Gall literature on indicators. One such requirement is participation and ownership, to which I will turn now. It is important to note that at the outset that knowledge governance is essentially controlled by the bank management so far, which produces all of the formal knowledge products mentioned before. To a certain extent, this makes sense because it is this international bureaucracy that houses the necessary expertise and is institutionally separated from interest-based politics. However, there may also be good reasons for a measure of participation by states and affected individuals in certain knowledge activities. From a functional perspective, more input from other actors can enhance responsiveness, it can improve the quality of knowledge products, increase their acceptance and impact, and thus potentially stimulate the diffusion of innovation. Secondly, from a more autonomy-related perspective, if knowledge predetermines policy, as critics argue, and sometimes amounts to the exercise of public authority, then collective and individual autonomy may require those subjected to this to have a say in its generation and use. This idea of epistemic ownership, as I call it, can arguably also be based on the bank's non-political mandate, which requires the bank to be impartial also in the knowledge activities, and thus to include reasonably significant criticisms and alternative views. An analysis of the existing mechanisms for participation and ownership shows that in this respect, there still is considerable room for innovation. We hardly find any specific legal rules, either on country level or on the global level. For country-level activities, some operational policies already express the general idea of epistemic ownership. They stipulate, for instance, that economic and sector work should be oriented towards the borrower's development strategy, which can thus be used to steer bank knowledge activities. They also stipulate on technical assistance that this should be based on active borrower participation. But again, there's hardly any specific legal rules that explicitly regulate procedures or actors in participation, namely by civil society or by project-affected individuals. On the global level, there's only a practice that gives the board of directors, which represents member states, the possibility to take part in knowledge activities and also to oppose or discuss specific knowledge products, for instance, in the World Development Report. This is, however, a rather piecemeal practice, which might not in all cases guarantee both the scientific quality and political direction for these instruments. Hence, it's worth considering scholarly arguments that propose that knowledge instruments, at least those that amount to an exercise of international public authority, should generally be based on an explicit mandate by the political organs of the organization. In the absence of sufficient rules on participations, finally, mechanisms that ensure review, contestation, and transparency become all the more relevant. One such mechanism is the independent evaluation group, which reviews knowledge activities, but is not available to individuals. This is the case for the inspection panel, which also has scrutinized preparatory analytical work for projects, but remains limited to projects. Consequently, much hope is placed in a last innovation, which is the last point here I want to make. That is the open knowledge, open data, and access to information policies, which have been enacted in 2010 and make most bank documents and knowledge available to the general public. This not only ensures transparency, but also gives states and citizens much needed agency to initiate knowledge flows and to publicly scrutinize formal knowledge products, which are necessarily more selective in the knowledge they present. Positive examples from practice illustrate that openness can both enhance epistemic ownership and contribute to innovation. As Bank President Zöllig put it, I quote, "One of the reasons we threw open the doors to our data was that we recognized we don't have a monopoly on innovation," unquote. In conclusion, and this is the last thing I want to say on this, is that the enabling and legitimating functions of law that I've pointed out earlier may thus not be too different from the point of view of innovation theory. For if innovation means not simply invention, but also requires diffusion and acceptance, then such acceptance also depends on the perceived legitimacy of the process in which innovative knowledge is generated. Hence, it's maybe by providing legitimacy to global governance of knowledge, that law can arguably make the greatest contribution to innovation and development. Thank you.
Thank you very much.
Hello. Hello everyone in New York. Hello to Vikram in DC. I'm also grateful for the opportunity to present some ideas of my PhD project in this context. And since the previous speakers have already very well introduced the World Bank as an innovator, I want to go straight into my presentation on the World Bank's innovations in regards to its engagement with fragile states. Because if, as Severino and Ray have famously diagnosed, the end of ODA is near, then it is not for fragile states, and that has also become clear with regards to Annalisa's presentation this morning. ODA constitutes the single largest resource flow to fragile states, which are states typically characterized by weak capacities, poor governance, political instability, and conflict. More poor people today already live in fragile states than in non-fragile states, and this is a trend which is likely to increase over the next decade. Against this background, old-school ODA is experiencing a surge of innovations in order to more effectively tackle state fragility, which is also increasingly seen as a global public good. The World Bank has been at the forefront of these innovations, and its innovations concern not just its risk-averse business models, approaches, and instruments that often prove inadequate in unstable and weak capacity environments, but the World Bank has also adapted its rules and procedures governing the transfer of ODA to fragile states. So it uses law as a tool to innovate or to consolidate innovations. It is these legal innovations that I want to draw your attention to in my presentation, not least since they can have significant consequences, both in material terms, insofar as they sometimes concern the access to and the allocation of resources to the most aid-dependent countries, and from a normative perspective, insofar as they modify the legal basis and terms of engagement in these countries. I want to argue that innovations may be seen as a necessary response to the specific challenges posed by fragile states, but at the same time that this notion of fragile states is both a social construction of Western security interests and an overly generalizing catchphrase for development challenges of extremely different states. So legal innovations that are based on such an ambivalent concept often rather amount to a selective bending of rules designed to protect the sovereignty of recipients or aid effectiveness, in order to facilitate engagement in a few fragile states, namely in those where the bank's most influential shareholders support it. Against this background, I want to propose that the role for law and for lawyers is to ensure that where these innovations occur and are actually consolidated in the bank's internal law, they are not mere disguise for perhaps necessarily political decision-making, but as far as possible, conform to standards of transparency and non-discrimination. I want to unfold this argument in 3 steps, which you unfortunately cannot see here, but that's my fault. I will first briefly discuss 2 examples of legal innovations at the bank, before taking a critical look at the causes and interests behind the fragile states agenda at the bank, and finally, with a more sober look, propose a role for law in this regard. So the 2 examples I have chosen stand for 2 different aspects of the challenge of engaging with fragile states. The first concerns the often deeply political question of how the bank deals with governments in fragile states. And the second concerns a more operational question, which is how the bank responds to their limited capacities. Now, first, the bank clearly needs effective governments as a counterpart to engage with, and governments are required to render consent, which thus serves as a legal basis for engagement. So the bank faces a challenge where a government counterpart cannot easily be identified. And this is often the case in situations post-conflict, where there's temporarily or even for prolonged periods of time no government, but also with regards to UN-administered territories, and territories with an unresolved legal status, like the West Bank and Gaza, but also briefly, for example, South Sudan. So in response, the World Bank adopted in 2001 an Operational Policy 230, which is an internally binding law, as we learned from Philip this morning, which contains the principles for bank involvement in conflict-affected states. And this policy now states that if there is no government in power, a request from the international community, and here I quote, could substitute for government consent. Moreover, this policy permits the bank to engage outside territories of member states if this is considered, quote, for the benefit of the organization as a whole. So on the basis of such legal reasoning, the bank had, for instance, engaged with UN interim administrations in Kosovo and in East Timor and started operating in the West Bank and Gaza. The relevant provisions are, however, formulated in strikingly vague terms with no decision-making criteria attached or any procedural requirements, and could thus be interpreted as leaving a lot of room for abuse or at least selective application. Meanwhile, theoretically at least, the effects of these provisions are considerable in that they modify the legal basis for bank operations in the most needy countries. To come to my second example, from a more operational perspective, the bank also faces the challenge that fragile states have often extremely weak capacities. And here I can refer to Michael Woolcock and Lan Pritchard's paper on capability traps, and which are responsible for persistent implementation failures in these states, and also to Benedict Kingsbury's and Kevin Davis' work on the problem of obligation overload to fragile states. From the bank's perspective, these capacity constraints in fragile states often prevent swift and effective engagement, as the government lacks the capacity to comply with bank requirements in order to qualify for assistance in the first place. In response, the bank now operates under emergency procedures in virtually all fragile states. By triggering this operational policy on emergencies, the bank can reduce procedural requirements and can postpone material requirements like the safeguards until later in the process, and it thus can enhance the speed, flexibility, and simplicity of its operations. Moreover, this policy allows the bank to assume a more proactive role in the implementation process. Now, so far, if the bank sought to use emergency procedures as a quasi-default option in fragile states, it had to repeatedly justify that an emergency still persists. Now, there's a brand new innovation, which is actually only going to be published tomorrow. So it's not yet in the paper, but I want to briefly point your attention to it here, which is the publication of the new operational policy of the World Bank on investment lending. And this new policy will now incorporate and mainstream this whole idea of fast-track, lighter procedures, more proactive bank involvement in the bank's most important lending instrument. It will become an alternative and no longer an exceptional mode of engagement that can be triggered in clearly defined situations, including fragility. I think this is an important innovation since it establishes firmly and for the first time also explicitly the understanding that fragility requires some form of differential treatment. Now, in sum, and without going into much more detail here, I want to suggest that the World Bank's innovations are beginning to yield certain patterns. Very broadly speaking, government ownership is often qualified in line with the apparent effectiveness of a government, while on the other hand, obligations on the government are increasingly adapted to reflect their capacity constraints. This is usually done through an interpretation of the bank's mandate, which is then authorized by the executive directors and often later formalized in internal rules, as we have seen. And these rules often leave a relative large room for discretion. So let me take a second look at the causes and interests behind this fragile states agenda. Because we may find that state fragility, or tackling state fragility, is one area where the World Bank will still be needed in the future. And we may also find that these legal innovations constitute a necessary and perhaps even long due adaptation of unrealistic premises, of overburdening rules, and of rigid procedures in light of a new challenge. But perhaps it is the very notion of fragile state that makes an international lawyer suspicious, or it's the fact that a phenomenon like weak statehood that has always existed at the margins of the international system now suddenly raises to the top of the international agenda. Because if fragility is not really that new or that different, we need to ask ourselves why they suddenly receive so much attention, who has an interest in making fragile states a key priority and trigger for innovations, and what these underlying causes and interests again tell us about the implications of these innovations. The notion of fragile states is, as I've stated, is clearly a social construction, which groups together very different states because they are seen to pose a severe development challenge or threat to Western security interests. This notion thus serves as a catchphrase for very diverse interests and agendas. As I elaborate in the paper, the emergence of the fragile states agenda at the World Bank must be seen in the broader context, first, of its evolving thinking on the role of the state in development. Nowadays, the effectiveness and legitimacy of state institutions have increasingly come into focus, and this is encapsulated in the success of the concept of good governance. So in this regard, fragile states are nothing else than the necessary opposite to good governance states. At the same time, since the 1990s, the international community became increasingly concerned with civil wars, with complex humanitarian emergencies, and post-conflict settings. And the bank had to demonstrate its continuing relevance in light of these shifting policy priorities, in particular of its major shareholders. It was suddenly asked to engage in post-conflict countries like Bosnia and to assist in building state institutions in Kosovo. But the focus on fragile states really only became explicit after 9/11, when weak statehood became identified as a security risk, and the World Bank responded immediately with the establishment of a task force on low-income countries under stress. This LICUS group is really the predecessor of today's World Fragile States agenda. I think against this background, it becomes clearer that the risk is that these legal innovations that remodel the World Bank rules and make them more flexible really benefit not all fragile states, but that it's the bank's most powerful shareholders which ultimately decide whether being categorized as fragile is an advantage or rather a disadvantage for a state in its dealings with the bank. Factual evidence could be seen to come from data on aid volatility and concentration, because now half of all ODA to fragile states is concentrated in just 7 countries, chief among them are Afghanistan, Iraq, and Pakistan. After this somewhat sobering view at the various concerns and interests that shape the fragile states agenda, I am tempted to conclude that law should play no role in formalizing innovations, in introducing differential standards in ODA, because at the end of the day, the danger is always that we are entrenching a differentiated status of statehood. But where these innovations occur through the medium of law, with the effect of remodeling rules of engagement and introducing differential treatment, I think law also has to play a role in ensuring that they are not merely a disguise for political decision-making. In other words, if we take law seriously, these legal innovations have to meet certain requirements. And the bank's own legal framework, its articles of agreement, already contain procedural and material safeguards in this regard. Procedural safeguards exist, for instance, regarding the adoption of legal innovations through amendment or rather through interpretation. It could also be added that internal rulemaking should follow minimum requirements of transparency and participation commensurate to the external effects of these internally binding rules. Also regarding the design of internal rules, lawyers have something to say about the clarity and precision of formulations, which can determine how much space they leave for abuse. For although discretion can certainly be warranted, I think we can at least expect a minimum degree of transparency in decision-making about when and how a rule is applied to different countries. Moreover, I want to propose that if legal innovations are introduced with the declared aim of facilitating and enhancing bank involvement in weak capacity environments, they should be applicable without discrimination among all potential recipients in the same situation, that is, for Togo as well as for Afghanistan. This idea is based on the principle that same cases be treated alike. And although it may be difficult to argue that the World Bank is required to treat all its member states equally, it is at least required by its statute to take decisions impartially and with no discrimination on political grounds. Finally, it remains to be seen whether such sporadic and so far really fragmented legal innovations that are being introduced at the bank will eventually be consolidated into a more consistent, structured regime of special and differential treatment for fragile states in development. I think it's not unlikely if we consider that tackling state fragility is increasingly recognized as a global public good, and maybe even more than development per se. And also the publication of this new OP 10 tomorrow could shed some light on the further development in this regard. If so, there's also a role for lawyers in assessing how obligations are adapted to the particular needs of weak capacity environments. And at the same time, lawyers may be called upon to ensure that differential treatment really does not amount to discretionary, ultimately discriminatory treatment. Thank you very much.
Thank you very much, Marie, also. And now we switch to you, Vikram. Can you still hear us? Okay, we can see you, Vikram.
Hear me?
Yes,
Hello?
we can hear you now.
Okay, great. Well, sorry, I said your colleagues insisted I be on the screen as well as speak, so sorry for this. Although I'm coming from different sources, my voice is being piped in and my image is coming through Skype. So, but that's fine. I guess that's enough to make up for not being there. I apologize I'm not there because of the last-minute notice that I was given, but also because of other scheduling conflicts here. It also means I haven't read the papers with the, the intensity I'd like to. So I'm sort of going to react off the cuff to the presentations that were made, which I thought were excellent, by the way. I think they were sparkling and really, I actually find them hard to sort of quarrel with, both normatively but also in terms of matter of World Bank law or policy in terms of the detail. I also want to say what I'm going to say now is really not in my official capacity, because I guess if I agree with them, I could possibly be fired. But basically, I think that as I've done before, let me react based on having the experience of working in the bank for a couple of years, especially on the fragility and conflict area, and also being exposed to some extent, although I'm no expert on the knowledge bank or the knowledge agenda of the bank. So if we can take perhaps Marie's paper first, as I mentioned to her when she met me last week, I actually think that there's a lot. It's a refreshing, very useful critique, which I think that large institutions like the bank definitely need, and I think we should welcome. I think that some of the questions she raises are definitely appropriate in terms of further divining to see what the basis for the bank's treatment, for instance, of this whole clause she finds in our in OP 230, which basically allows the bank to engage in a country where there is no government in power at the request of the international community. I think she stumped me when she asked me the other day where that came from, and this morning I spent some hours trying to look at the bank's Travaux Preparatoires for 230, and I think from what I've looked at quickly, it looks like it just came off the cuff, as often is the case, from the bank's general counsel then, who was asked at a World Bank board meeting, well, what do you do about countries like Somalia and Afghanistan? This is in pre-2001. Do we not engage there because we're looking for a counterpart that can consent? And then I think the General Counsel, and I'm going to try and read from the transcript, says that he sort of enunciates all the principles for World Bank engagement in situations of conflict. Then says that the bank must not operate in the territory of a member without that member's approval, and then goes on to say that if there is no government power, bank action may be initiated by request from the international community. And he then immediately caveats it by saying, well, which should obviously not be in the form of request for loans, and then this community must be properly represented by UN agencies, and then subject in each case to the prior approval of the board where all bank members are represented. Now, this comes from the authority of Ibrahim Shihada, who I think anyone would tell you was probably the most dispassionate when it came to bank law. I don't think anyone could accuse him of having an agenda or of carrying water for a certain, ideology. And that doesn't mean, of course, this somehow is infallible. I do think what it means is that this was a pragmatic legal interpretation of a charter which was already, 40 years old. And the question was, what do you do in states where you don't really have a counterpart that you can find, to go and engage? And I think it's, at the end of the day, a pragmatic compromise, which may not be perfectly sort of legally locatable in the bank's articles, but I do think it sort of reflects the spirit of the articles, which by themselves, by the way, also both IDA and IBRD, the two parts of the World Bank, if you will, their articles do recognize this idea that there are places where you may not have a proper state. In fact, you look at IDA's articles, they talk about territories that are in association with member states. IBRD's articles are similar. So this idea of countries where the sovereignty question is somewhat complicated or less than optimal is something that is present at Bretton Woods. And I think in some sense this is a sort of pragmatic continuation of that. The other point I'd make in terms of Marie's presentation, I agree that I think I wholeheartedly agree. I don't think it's the business of law in terms of at least World Bank law, and I think we can debate to what extent OP 230 is part of that legal architecture of the bank. I think some would argue, based on the Vienna Convention, that it is, and some would say, well, no, it's just a policy document. It's not hard law. It's not a legal opinion. It's certainly not something that has enjoyed the status of the Articles of Agreement or an interpretation by the Board of Directors, a statutory interpretation. But if you look at OP 230, I don't think that OP 230 itself, in some sense, strictly classifies countries between conflict or fragility. It introduces, in some sense, sort of an operational classification. But it does not enjoin the bank as a matter of law or strict policy to then distinguish in terms of how it should engage in these countries. I actually think that 230, at least my reading of it, is almost a helpful guide. There are some parts of 230 which codify bank jurisprudence. But the rest of 230, or 230 as a whole, I don't particularly think rises the status of articles type sort of law with a hard bite to it, that then somehow binds the bank in terms of how it does business. And I think that 230, while it outlines sort of boundaries or parameters of what the bank can and can't do in a conflict situation, then gives a lot of flexibility to the bank in terms of how to implement that operationally. And I don't think that this is any great departure from the bank's commitment to the rule of law or its own sort of legal and institutional architecture. If you take, for instance, the whole concept of graduation from the bank, something that comes into bank law and policy in the 70s and then is codified in the early 80s through the bank's graduation policy. In the bank's articles, there is no distinction introduced between its member states. All member states of the bank are eligible to borrow. But since the 1970s and the 80s, a number of countries graduated from the bank. In other words, the bank considered the fact that they reached a certain level of development, measured both technically in terms of achieving a certain per capita income, GDP, and then also substantively in terms of them having access to capital markets and institutions, both social and economic, to enable them to progress economically without bank aid. That innovation, policy innovation, is really not reflected in a legal opinion. Well, it is sort of, in some sense, defended in an opinion, but it's not something that's required on the article, strictly speaking, although you could locate an article's basis for this practice. So similarly, in the context of banks' distinction of treatment of conflict and fragile situations, I think it is like graduation in innovation the bank has reached. And I think there, I agree with Marie, that maybe in part because this is in some sense such a flavor of the moment, it's best not to codify this. And I don't think anyone within the bank would also argue that we need to hardwire our definitions or distinctions on fragility and conflict. And the only other point I'd make is a lot of those definitions really creep in from the IDA replenishments, from what the donors require the bank to do. And so again, anyway, I think I should stop there because I'm not supposed to be going on and on for a discussion. But let me quickly then go on to the, well, actually, no, sorry, I just had one other quick point which I think needs to be addressed. The equal treatment principle. Again, I think this equal treatment principle is always a challenge. It's somewhat abstract to apply, especially in a country, in an organization which, unlike the UN, is weighted by shareholding and, quite, sort of blatantly does distinguish by, in terms of how much voting power its countries have because of the amount of shares they hold. So that already is a big exception. And then applying the equal treatment principle, I think, is always challenging, especially in these low-capacity environments, because how do you then make sure that you absolutely treat Haiti from Togo, the same way as you treat Togo or Afghanistan? And I think that is a fairly large challenge. And so that's where I think that it may be very difficult to compare apples and oranges. Now, finally, to go on to Michael's presentation, again, I thought I learned a lot from it. And again, it's not an area I know much. But I do think there's one point that I think may be worthwhile in further refining the paper, if that's really the intention, which is to look at the bank's new framework for what is called reimbursable advisory services. The old name was FBS, fee-based services. These reimbursable advisory services, I guess I've been disconnected, but I guess, can you hear me? Hello? Can you hear me?
Yeah, we can hear you.
Okay, well, I'll wind up. But basically, I think what Michael's paper would really benefit from is a look at the RAS, which is sort of one way of the way the bank sort of engages or spreads the gospel of knowledge across the world. But RAS is basically the bank's new operational tool to really engage with a country through technical services, which are not lending, not infrastructure, where the bank really goes out and, in some sense, gets a fee, like a consulting firm, to provide advisory services, being used in a number of countries, including, in some, to my surprise, in some recent cases, in some fragile situations. But the RAS framework also comes with a lot of bells and whistles in terms of crowding out private sector consultants, in terms of it causes a lot of issues, it throws up a lot of issues for the bank legally, privileges and immunities, how do you make sure that you're protected from being sued, and I think that Michael's paper would benefit from a lot from looking at this model and perhaps critiquing it, because I think for some reason it hasn't really got the attention that it deserves in terms of legal or even in some sense operational scrutiny. So I'll stop there and perhaps come in later if there are any questions.
Thank you very much, Vikram. That was really extremely enlightening and rich. And now perhaps we open the discussion here in the room. There are two people still on the list from the previous session, so perhaps we'll start with those two, and then if further questions come up, we'll bring them in. We have a little more time than on the program is indicated, because lunch is just outside here, so we don't have to strictly break for lunch at 1 o'clock, but if more questions arise, we should take the time to discuss them. So the first on the list is Tim Büte.
Thanks. Let me actually make a brief comment with regard particularly to the first presentation, and then link it back up to one of the issues that I was concerned about with the previous one. This issue of knowledge production, I think, is certainly a very important move on the part of the World Bank because it has the potential, at least, to address one of the key concerns that especially the BRIC countries have raised regarding the entire sort of Western post-World War II development assistance model. Namely that a lot of the kind of technical assistance that they feel they really have to offer essentially is not valued because there is no immediate monetary value that can be assigned to it, and in fact they think the potential is much larger than anything that sort of standard models of the costs of technical assistance actually has to offer. Now I'm afraid that probably legal expertise has a rather limited potential here to improve the situation. Sure, there can be rules put in place that require some kind of evaluation of these things, and hopefully that would encourage, I suppose, mostly economists and maybe to some extent political economists to actually come up with proper valuing models for this, but I don't think law in itself has all that much to contribute beyond providing a framework for it. With regard to the presentations before, it struck me actually that the discussion of this financing for outputs or results in a way actually is a very nice illustration rather than necessarily a challenge to the arguments that we heard before about the limitations of public agencies to actually innovate. It's not that they are unlikely to innovate because they lack necessarily the information or because they lack the brain power or the flexibility in terms of their thinking, but because they have procedural limitations on actually implementing these things. At least that's how it seems to me from the admittedly anecdotal perspective of having been approached from a few of the people inside the World Bank who've been pushing this for several years now. We were first in contact about 3 years ago, and they thought then they were just around the corner, a few months at most, from launching this on a large scale, and then they were sort of reasonably under the radar screen brief emails and a call saying, well, we're facing some difficulties within to actually get this program established because there was a massive opposition to doing anything of that sort whatsoever, to doing it on a larger scale as they had hoped. And they didn't just come up with this out of the blue. There had been some pilot projects that they actually had done essentially along these lines, both within and without, that suggested to them that this actually had a lot of potential. But actually changing course in an organization that has a certain degree of consensus requirements and has a lot of veto players is very difficult.
Michael, you want to respond immediately?
Yeah, I can just briefly react to Vikram's comment and to what Tim said. Reimbursable advisory services, or I think fee-based services, as the knowledge report of the World Bank placed it, is certainly important. To my understanding, in the 2011 knowledge report that the bank put out, it was still a minor issue, but it probably seems to have become more important. And for particular countries, again, BRIC countries notably, and I will make sure to look at this and give it more space in the paper. And also to somehow put it into the structure that the bank had itself established for the codified knowledge products, where it doesn't figure as of now as one of those core knowledge products that they've defined. So there seems to be a lot of flux also in terms of the defining the ways the bank formalizes its knowledge products. I'll look into this, so thank you for that comment. Regarding Tim Bute's comment on the limited or whatever role of law that there might be, I think this is what I wanted to say when I tried to talk about the governance models that law employs here. It's probably less really regulating knowledge in the way that capital is regulated and putting a monetary value to it. However, it's more this context governance and the provision of incentives where law can play a role. And by constructing knowledge as a manageable package of information, that's what the rules that the bank issues on knowledge products are for. And I mean, this money is not very different in this when we look back 200, 300, 400 years. That's also a construct that is subject to similar rules. It's just that we've been used to treat money in this way more. So I do think that the law can play a role, not directly as you say, but more in providing this framework of incentives and enabling context, and that's already something, I would argue.
Lorenzo?
Thanks. As a quick comment, it's related to the previous and to these sessions, and then I think it will turn into a question that was thought for Philip, but it might be addressed to Michael and Maria as well. The comments start from this, from the comparative administrative law perspective, and also from the global administrative law perspective. The World Bank is really a prime example of how to affect and to have impact on domestic legal context, especially thinking of participatory rights. Now I'm relating exactly to the example that Philip dealt with in its presentation, his presentation, when you have to fund projects, so the operational policy can pretend that participatory rights are granted and accorded to indigenous people, for example. Now, from this aspect, if I read the policy that you consider, the 9.0, I see that there are basically the same provisions, special attention due to the rights of indigenous people and these kind of things. Now, this has always been a very important example. I'm not saying that it's necessarily positive. Some say that it's a sort of Western civilization or kind of imposing these kind of principles. But now the question is, according to what I heard from your presentation and also from the others, this aspect of using participatory rights in order to develop law has not been stressed enough. Now, the question is why? Perhaps is this perception that I have that comes from GAL and comparative administrative law wrong or partial, or quantitative, from the quantitative perspective, is not so relevant? So this is my question.
Yeah, thank you very much. I mean, I just quickly respond to that and to what extent participation of, let's say, project affected takes place. But I think we have to distinguish between their participation in how a certain project is shaped and framed and general lawmaking in the bank as such. Because for the latter, for the general lawmaking, so for the way a World Bank new OP or BP is drafted, there the bank has in practice instituted a way of consulting with constituencies. But that is, as far as I can see, not really formalized in any sort of internal lawmaking procedure. So there's no sort of formal procedural rule which divides that. So the bank does that, and it does that frequently, but there's no specific rule. And you can very well argue, and I would be with you there, that this should happen, that it should be sort of more formalized and more thought through who would be consulted and not. If you look at the participation in the concrete project, there it becomes a very complex picture because it depends very much on to what extent the project at hand carries certain risks, let's say for indigenous or for people or for environments. And you have certain different categories, category A, B, or C of the project. And to some extent you can say in very high risk projects there is actually a fairly sort of extensive role for the participation of project affected. But here comes the problem. The problem is the law in the books and the law in action. The law in the books, you might argue if you want to be sort of sympathetic to the bank rules, the law in the books looks good. Yeah, there are rules. You can say they have been sort of taken on board. But if you go more to the inspection panel cases, which sort of go through certain problematic cases, also with respect to participation, then you see how much or how little, I should say, how little these participatory rights have been respected in reality, or how difficult it is to actually sort of put them in reality. So I think there is a lot of scope for improvement in the compliance with these rules of participation. Thank you. Now there was one more question from Devesh Kapoor. Any more before we break for lunch? Any more?
Can I just make a quick point, Philip?
Yeah?
I just wanted to make sure I understood what you said about bank policy. As a legal matter, but also as a practice, the bank board is actually quite actively involved in the making of any policy, although they may not actually approve the wording of specific policies because of a historical practice. But in terms of, if I understood you correctly, the bank's board does sign off, and they did sign off on the indigenous peoples policy as well.
No, just to respond, I didn't mean the board. The board is certainly involved, especially in sort of agreeing with the principles. But the question was, as far as I understood it, more about sort of project affected. So individuals in developing countries, to what extent they would be taken on board. Okay.
Just two comments. One for Michael. You know, what exactly is the word, like, knowledge? What does it actually mean? I think a bit of this turn of the bank as a knowledge bank is a bit of pompous fluff. What was the bank when it was established? At that point of time, the way knowledge was thought about was more tacit. If you look at the first loan for power, it was a 3-page document. By 1980s, because of all the issues we know, the documents were 500 pages plus. There is absolutely no evidence the projects were any better. In part because the way we think about knowledge changed within the bank and outside. Prior to that, knowledge was embedded in sectoral expertise, people who had worked in the power sector for 20 years, 30 years, before they were hired within the bank. They were not self-consciously in the area of knowledge production. Later on, the bank's expertise changed to people, the sector people were ousted, and that's even worse now. And the people who are so-called in the knowledge space are mainly from the economics profession, whose, therefore, their own experience of a sector is much weaker, and they need 300 pages in order to justify that this project is worthwhile. So you have to really think about what you actually mean by knowledge, separate between tacit knowledge and the production of volumes of paper as knowledge. These are two very different things. So unfortunately now the bank and people who look at the bank, which includes lawyers, they look very much at explicit outputs and think that is the only way that we think about knowledge. But whether you look at the way we think about knowledge of indigenous peoples who don't have explicit ways of codifying knowledge, uncodified tacit knowledge was always critical to the bank. If the bank was only a lender, it would be as small as the European Investment Bank. You just write a check. Why do you need all these people? And the reason you needed all these people was it always felt that the money came with a package of expertise, and that expertise you might call knowledge. And that's the difference, the way the bank has evolved. One point for Marie is, why do you think the bank, the prior question that I would ask is, why should the bank at all be involved in fragile states? We have a global system where we have multiple UN agencies. Why should we not ask the prior question, should that not be the work of agencies like the UNDP? Is that the comparative advantage of the bank? And why do we have these multiple agencies already existing, and might they not have a more comparative advantage? Why do we think that the bank needs to be in this in the first place, other than an institution which thinks it is the best thing for everyone, everywhere?
Perhaps we take in one last question and then we round up with answers. Raghavan?
My questions and comments are actually posed to the previous panel, but also taking advantage of the fact that we have Vikram Raghavan online. And I had briefly talked to Devesh Kapoor about this outside. This question of whether IDA lending has really peaked and the demand for it decreased, with the example of India, where in fact I think there is an increased sense of, and perhaps this also ties in together with some of the comments made by the discussant in the previous section, whether we can really, these middle income versus low income country definitions are problematic if you just apply them to the entire state level, right? India is one of the World Bank's biggest borrowers and has significant pockets of poverty and social indicators. And so I'm wondering whether Vikram has any insights on whether there is increased differentiation within countries like India to want to actually not graduate from IDA and use IDA financing for poorer states within the country. And then to Philip Dunn's comment that the bank is institutionally well set or able to react, I'm wondering if there could be some discussion of it might be institutionally well set up, but is there the political will to actually change? I hear that there's some discussion in the US Congress about financing and issues of whether one wants to not perhaps increase financing in order to not lose voting power, which is probably a similar discussion in many of the major shareholders of the World Bank. So those as comments and sort of questions for general discussion.
So I'll just start and then you have the final words. Just on this, my thesis of the World Bank being institutionally well set up, it's basically drawn from a comparison, especially with the UN system of development finance. And my observation here is just that it's so much less well structured in the way the UNDP and other UN agencies deliver aid and is able to react to changes. So especially from that comparison, I would say the bank is remarkably, in that perspective, in that specific comparison, remarkably reactive. I mean, this P4R is just one example of a much bigger ongoing reform of the lending instruments. And I mean, I'm not saying that it's, I'm not trying to idealize it. I'm not trying to say it's the perfect institutional actor, and I take into account the question mark behind the sort of veto player structure in the bank too. But I think in comparison to other international organizations, the World Bank is at least able to somewhat react. It is, of course, I mean, that's always like, it's principal and agent at the same time. It is driven by certain actors, it is pushing for certain actions, but at least you have the impression that the institution tries to adapt. That's what I thought.
Okay,
did you want me to answer the IDA question?
Oh, yeah. I'm sorry, Vikram, please go ahead.
So just very briefly, it's not an area I know much about, but India is a blend country and a candidate for IDA graduation. Therefore, access to IDA beyond fiscal year 2014, from my knowledge at least, has not yet been officially determined. At their first replenishment meeting last month in Paris, the IDA deputies for IDA 17 endorsed the proposal that India would receive so-called transitional support after it graduates from IDA, but a final decision will not be taken until the end of this year. Now, I do think that, but the point that was made, that there obviously has to be differentiation. You have what you could classify as fragile states within India, as well as then very rich middle-income countries, which should probably be graduating from IBRD also within the same country, is a challenge. But unfortunately, the bank's legal architecture only enables it to engage the member country as a whole, and that then causes the, if you look at IBRD, India's ability to use IBRD to make up for IDA is limited by what's so-called single borrower limit, which is currently set at 17.5 billion, which is peanuts for a country that can absorb, which needs 600 billion, you know, if it wants to improve its infrastructure. And so therefore, actually, the bank is severely constrained in some sense in responding because of its financial base, and this is not a, this is a matter of public knowledge. But yes, I do think that there's a great case for differentiation, but unfortunately because of the Articles of Agreement, we can respond more effectively to small countries like Tonga and small Pacific islands than to the state, to, let's say, Bombay municipality, in part because it will require the central government to come in and, stand behind it in the form of a guarantee.
Thank you very much, Vikram. And now, Michael.
Okay, thanks to Devesh Kapoor for this, for the helpful comment. Of course, if I talk about a law of knowledge, I need to define what knowledge is, or at least differentiate the term, and I do that in the paper extensively. And of course, there's different types of knowledge, and tacit and implicit, and so on. And but when you look at the World Bank knowledge documents, you will find that they often use the notion very indiscriminately, and a very wide notion that includes data and information, which I would distinguish from knowledge already. And then there's different types of knowledge, like economic knowledge or more engineering type of knowledge that you need when you do infrastructure projects. But the reason that these types of knowledge become focused on or become valued or not valued in the bank, it's not haphazardly. It's a result of a governance decision, is a result of a particular institutional context, and that is subject also to legal influences and to management decisions. So the reason that now the economists or more economic knowledge was privileged for a time resulted from a certain management or governance decision, if you will. So staff management and human resources is hiring and promotion practices is of course one issue that also has a legal dimension to it that the bank will engage with in some of the more upcoming knowledge reports, they say. There are already reports that touch on that, measures that touch on that, tacit knowledge, such as the network structure and staff mobility within the bank. So to a certain extent, that is also an issue of organizational rules for law. But generally, I, of course, agree that one of the tasks that academics and legal academics have is to also differentiate these notions of knowledge as they're being employed in practice in order to make sure that when we talk about the legal instruments that we apply to them, we find the most suitable ways. And that might also be to find ways to govern or make sure that we make use of tacit knowledge, which is probably not be done in the most efficient way as it is right now.
Again, thanks, Devesh. I think this is a very valid question, whether the World Bank has any comparative advantage of engaging in these settings. And I don't really want to provide a definite answer. I mean, first of all, even World Bank staff question whether the World Bank should get involved in these settings at all. I could maybe only ask back what the comparative advantage of UNDP would be, and because you could also say that the World Bank has at least theoretically this non-political mandate, which could be an advantage in this type of settings. Plus, I want to point out that, interestingly, what we can see with regards to fragile states is that the UN agencies have much increased cooperating with the World Bank or the other way around. And we also see an increased cooperation between development agencies and other agencies like humanitarian agencies. So perhaps this is again, evidence for the fact that this tackling state fragility is seen as a global public good. Thanks.
Yeah, thank you very much to the two presenters, Marie and Michael, for their presentation. Also, thank you very much, Vikram, for your comment and participation in the following discussion. Now we break for lunch. All speakers and discussants are invited for a little lunch, which is here just outside our hall. And as I heard, everyone else was also given a certain list of attractive venues just around the law school. And I hope we'll all come back together here at 2 o'clock. Thank you.